My lord, the challenge in the petition is annexure P1 at page 17, which is an order which has been passed by the MSME Council.
There's a statutory appeal, my lord. We have taken an objection. There's a statutory appeal, my lord. Under 34, we have taken an objection.
They
तो पैसा जमा करना पड़ेगा ना?
They have taken an objection, my lord, but I have
पैसा जमा करना पड़ेगा.
पैसे जमा करना पड़ेगा.
Section 19 says that the 75% of the amount
हाँ.
of an award which is passed under section, the use of the word is award.
हम्म.
The challenge in this petition, my lord, I have a singular ground. Section 18 of the MSME Act talks about how to adjudicate an application which is filed under section 17 for.
Fine. If you say that authority had no jurisdiction and has passed the order,
Yes, my lord.
then I can understand.
Yes.
If you if you say that it is bad because of these reasons, file an appeal.
My lords, my submission is that the order which is passed before my lords is without jurisdiction. This is
Whether the authority is competent to pass any type of order or not.
my lord, the answer would be no, my lord. As per
मतलब वो सपोज किसने ऑर्डर पास
the
किया है?
MSME Council.
तो MSME फैसिलिटेशन काउंसिल को ऑर्डर पास करने का जुरिस्डिक्शन नहीं है.
नहीं है.
नहीं, किसको था
My
जुरिस्डिक्शन?
lord, either they take up the matter through conciliation, or if the conciliation fails, then the matter has to be taken up through arbitration. Either by the MSME.
ठीक है, तो ये अपील पे डिसाइड नहीं हो सकता.
Either the.
अरे अपील पे डिसाइड नहीं हो सकता.
My lord, my
Merely because you will be required to deposit certain amount, can it be a good ground to bypass the statutory remedy?
my lord, respectfully, that is not my ground why I have filed this.
No, I'm not saying.
Ji.
Certain things they go on without saying.
In this case, it is not because I have.
Certain things go on without saying.
Yes, my lord.
है ना?
In
अगर आपको मालूम है, सुंदर जी को मालूम, अगर मैं ये ग्राउंड लूंगा 1 सेकंड के अंदर उड़ जाएगी पिटीशन. तो ऐसा है, मुझे भी पता है कि कौन आर्ग्यू कर रहा है सर. तो
आप अगर सिर्फ 2 मिनट मुझे सुन, there's only two.
अरे मैं तो 2 घंटे भी दूंगा. सवाल इस बात पर प्रश्न वहीं पे आने वाला है जहां पे if the authority has no jurisdiction at all, suppose if the power was to be exercised by say commissioner,
my lord,
it was done by collector, fine, no difficulty. If the power was to be exercised by commissioner but he has not exercised properly, then why should I bypass the statutory remedy?
In this case, if my lords would have a reference of the MSME Act, section 18 does not.
Law यार, साहब ने भी मानना नहीं है.
नहीं सर, मैं
फालतू अपने समय खराब कर.
मानने वाली बात नहीं है सर. I'm just submitting certain.
Last occasion.
सुंदर जी वो sarcastic नहीं है. मेरा कहना ये है कि लॉयर्स को इतना इजीली सरेंडर नहीं करना चाहिए. तो वो sarcastic नहीं है.
So
derogatory भी नहीं है.
नहीं सर, आपकी तरफ से कभी कोई ऐसा नहीं आता.
वो हमको ये समझ में आ गया कि आप सरेंडर नहीं करने वाले, तो अब फिर आप कानून के हिसाब से पढ़ते हैं. ये मैं कह रहा हूँ.
मेरा सिर्फ एक, I only have one point for filing this writ petition. The rest of the points I have not gone into because it's a matter of.
तब तो पेपर किताब आ जाएगी. You are referring to the section.
My lord, section 18, my lords, may kindly say.
Reference to micro and small enterprises facilitation council.
Yes, I'll just read from subsection 2 till subsection 5. On receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternate dispute resolution services by making a reference to such an institution or center for conducting conciliation, and the provisions of section 65 to 81 of the Arbitration and Conciliation Act 1996 shall apply to such a dispute as if conciliation was initiated under part 3 of that act. Where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer to it any institution or center providing alternate dispute resolution services for such arbitration. And the provisions of the Arbitration and Conciliation Act.
आपकी order sheets कहाँ file की?
हाँ, मैंने की है सर. The order sheets, my lords, would file the IA which we filed on 12th of April 2024, my lord.
12th of April 24. जी sir.
My lords, may straight away come to page number 4 of my IA. This is the first order dated 2/9/2020. Let's may I read the order?
जी सर।
अभय पक्ष उपस्थित, आवेदक ने अवगत किया कि अनावेदक के प्रदाय आदेश दिनांक सो से आवेदक को सीमेंट मिल 2 बनाने हेतु सर्विस देने के लिए नियुक्त किया गया था। आवेदक की निर्माण संबंधी मशीनरी का किराया सो प्रतिमाह की दर से 3 माह का किराया सो आवेदन प्रस्तुत करने के दिनांक तक दावा किया है। इस प्रकार कुल राशि सो एवं दिनांक सो तक की ब्याज राशि सो तक का दावा आवेदन पर प्रस्तुत किया। कृपया आवेदन से दावा आवेदन अनुसार भुगतान कराया जाए। अनावेदक ने अवगत कराया कि उनके सो आज कोर्ट में संबंध होने के कारण नहीं है, अतः प्रकरण में आगे समय चाहते हैं। अनावेदक ने यह भी अवगत किया कि प्रकरण माननीय उच्च न्यायालय जबलपुर में याचिका क्रमांक RP 864 ऑफ 2022 विचाराधीन है, अतः आवेदक का दावा आवेदन।
अच्छा, आप ये बताइए 18(2) कंपल्सरी मैंडेटरी है और नॉन कंप्लायंस वुड nullify the proceedings.
मतलब इट इज अ मैंडेटरी
बस उतना कोई जजमेंट बता दीजिए।
मतलब उसके लिए मैं एक चीज रेफर करना चाहता हूँ।
हाँ,
मतलब दी if Malots would take recourse of section the arbitration,
अरे कोई जजमेंट हो तो बता दो ना,
the procedure,
क्योंकि इसमें प्रकरण अंतिम है सब मध्यस्थम आदेश
हाँ,
पर नियत किया
हाँ,
गया।
वो किया गया। अब लास्ट ऑर्डर शीट एक बार देखिए।
मेरे भाई पहले आप कानून उतना तो बता दो। इट इज मैंडेटरी एंड इट विल vitiate the entire proceeding.
Malots, the statute, what this is a special legislation, Malot, a benefit.
मेरे भाई कोई जजमेंट इस पे है कि
उसमें
नहीं?
है कि the procedure what is enumerated and the act has to be followed as it is, Malot.
नो प्रॉब्लम, नो प्रॉब्लम। मेरा ये कहना है इट वुड vitiate the proceedings.
It would vitiate the
बस
proceedings.
उतना जजमेंट दे दो ना।
Malots में kindly refer 1996 volume 5 SCC 460 and 1999
एक सेकंड 1995
1996 Malots
1996
volume 5
हाँ
SCC 460
हाँ
and 1999 volume 7 SCC 88. I'll refer-
88
88, my lord. Paras in 99 judgment, the para would be 11 and
एक सेकंड
96. My lords, my first.
मेरे भाई एक किताब है।
जी। पहले 99 रेफर कर दे सर।
भाई पहले आपने कौन सी लिस्ट दे रखी थी कि हमारे यहाँ किताबें निकली होंगी?
मैंने एक बार दे चुका था ना।
अच्छा, उस दिन बहस क्यों नहीं की थी फिर?
वो पास ओवर हो गया था सर। एंड
पास ओवर में क्यों नहीं आए थे?
and senior was not available on post lunch, my lord. That's why the matter has been kept.
अच्छा, तो हमको 2 मिनट तो दो फिर।
जी।
1996 वॉल्यूम 5
पहले 99 ले लें सर। पहले 99 फर्स्ट my lords में टेक।
हे भगवान
1999 volume 7
Page.
88
जी।
आने दीजिए, हमारा कंप्यूटर भी हैंग हो गया। चलिए 1999
volume 7 SCC 88. That is the citation. The relevant paras are 11 and 12.
पोस्ट ऑपरेशन पोस्ट डिसीजनल हियरिंग वाला है क्या पहला केस? तो आपका
This matter is, my lords,
1999
Volume
वॉल्यूम
7
7
पर 89 करे सर। उसको 88
ऐसा कर रहे हो?
एक को एक पेज 89 करना।
आपका एक पेज में तो हमारा वो
हाँ, वो गड़बड़ हो गया सर।
गड़बड़ हो गया ना। जी चलिए बताइए।
स्टाइल
एनडीपीएस में कहाँ चले गए आप?
नहीं, मैं उसमें नहीं गया। मैं ओनली ऑन द रेशियो व्हाट हैज बीन लेड डाउन इन पैरा 11 and
88 पे एनडीपीएस है।
हाँ, वो है। पर एक बार पैरा 11 12 देख।
अब देख ट्रेन छूट रही क्या? मैंने आपसे पूछा था 18(2) के बारे में कोई स्पेसिफिक जजमेंट आया है क्या?
सर 18(2) के
पहले तो इतना बता दो कि है कि नहीं है
सर।
फिर देखिए, फिर हम उसके एंगल से अगर नहीं होगा फिर हम लॉ के हिसाब से उसको देखेंगे।
उसमें सबमिशन ये है साहब कि जो इशू व्हाटएवर हैज बीन डिसाइडेड बाय द सुप्रीम कोर्ट एंड अदर हाई कोर्ट्स आल्सो, इन दैट केस द अवार्ड वाज पास्ड बाय एन आर्बिट्रेटर। दिस इशू वेयरइन द
मैं वो नहीं कह रहा हूँ सर, आपका कहना है 18(2) का कंप्लायंस नहीं हुआ है
जी।
तो वेदर इट वुड विशिएट। अब आपने जो 2 जजमेंट दिए हैं दे आर रिलेटिंग टू द जनरल लॉ,
यस माय लॉर्ड,
राइट? मेरा पहला क्वेश्चन था 18(2) के ऊपर कोई लॉ जजमेंट है क्या? अभी तक
स्पेसिफिक 18(2) पे तो नहीं है।
नहीं मिला, वही तो मैं पूछ रहा था। पहले ये स्टेटमेंट आ जाए तो देन वी विल कंसीडर।
लेकिन सर जो रिव्यू पिटीशन का which is mentioned in the order sheet which I refer to fellows, the division bench has interpreted the provisions of section 18(2).
अब
of-
पैराग्राफ 11 जो कहता है 99 का, इट स्पीक्स अबाउट द नेचुरल जस्टिस
every administrative orders and not sick only
are required to be made in manner of consonance with
the rules of the natural justice when they affect the rights of the citizens to the property.
नेचुरल जस्टिस का कहाँ वायलेशन?
The courts are more concerned with the decision.
तो यार ये तो सिंपल सा लॉ, इसमें जजमेंट की क्या जरूरत है? वी आर कंसर्न अबाउट दिस डिसीजन मेकिंग प्रोसेस।
The decision.
आपके जितना कॉन्ट्रेक्चुअल मैटर्स है इसी बेस पे तो चलते हैं,
जी।
है ना?
Specific on section 18(2) my lord,
अभी तक नहीं मिला।
अभी तक नहीं है because this issue has only been raised.
पहली बार सुंदर जी ने उठाया है।
नहीं सर, बाकी हाई कोर्ट्स में सर वो आर्बिट्रेशन हो गया था एज पर दी एमएसए में।
नहीं, अरे यार क्वेश्चन तो पहली बार आपने उठाया, ये मैं पूछ रहा हूँ। यार पहली बार उठाने में तो तारीफ हो रही है कि बुराई हो रही है? तो जहाँ बिल्कुल शांत खड़े हो गए।
नहीं सर,
तारीफ ही हो रही है ना सर?
जी।
तो इसमें शांत क्यों खड़े हो गए सर? जी सर।
ठीक सर, तो
अच्छा, अब आप मुझे ये बताइए, आप अपन आ जाते हैं, अब आप 21/7/2023 के ऑर्डर पे आ जाए। आई थिंक दिस इज दी, है ना
जी। इसके
प्लीज रीड आउट द फर्स्ट लाइन।
मतलब सुनवाई दिनांक 21/7/2023 को अभ्य पक्ष उपस्थित हुए। आवेदक ने अवगत किया कि पिछली सुनवाई बैठक दिनांक 3/3/2023 में अभय पक्ष के बीच सुलह विफल हो गई। कंसिलिएशन फेल्ड।
हाँ तो फिर
Now, if the conciliation fails, my lord, as per section 18(2), the next step which has to be taken is for arbitration as enumerated under the act.
हाँ, तो क्या करते हैं उसमें? क्या करते हैं
उसमें सर arbitration के लिए either the council can itself take up the matter for arbitration, which the act says so,
हाँ,
or they,
फैसिलिटेशन का काउंसिल ने लिया है उसको।
but the order
They
sheet,
themselves can do it. It's head by Supreme Court, my lord. We have filed that R1 may be seen for a moment, my lord.
if I
It is not maintainable.
That's
And this is recent judgment of 2023, my lord.
My lord, I am aware of the judgment what
That they cannot bypass it, my lord. And this
I may
paragraph
just
is paragraph
I may
15, my
just
lord.
be allowed to-
Now he is arguing on merits, my lord, which he cannot, my lord, without depositing
because
that
my
amount.
entire stand
Now
is
the
to
entire
question-
stand is to save that 70.
No, it's not about
75%, my lord.
Never the if
अरे यार आप सुंदर जी से ऐसा ग्राउंड एक्सपेक्ट करोगे क्या कि जो ग्राउंड बोलने से खत्म होने से पहले ही रिजेक्ट हो जाए? मैंने तो कहा ना कि why he has not taken that ground. He knew कि the moment he would say the petition would go.
that's true, my lord. That is
तो इसलिए अरे instead of appreciating him that he is trying to take up only that issue which can be argued, आप कह रहे हो कि साहब आप हिडन एजेंडा जो भी हो, we are not concerned. We are not concerned. That is a part of advocacy. If he says कि साहब ऐसा ऐसा है तो ठीक है। हाँ, अगर ये ग्राउंड लेते हैं तो then I would have thrown the petition immediately then and there. तो आप सुंदर जी को तारीफ नहीं करना चाहोगे?
नहीं, मैं बिल्कुल करना चाहूंगा।
करना चाहेंगे ना?
हम छोटे भाई।
सुंदर जी इन्होंने आपकी तारीफ की, तब आप इनकी बात मानना नहीं चाहोगे। Anyhow, now 18(2) is over.
my lord, there is
I was under impression that 18(2) was not done.
no, my lord,
18(2) was over.
my lord, there is
Just a minute.
Yeah.
Dispute for arbitration. Arbitration का क्या मतलब है? Deciding the matter on merits, और फिर से आपके साथ बैठते हैं?
नहीं,
अब
arbitration
reconciliation और arbitration दोनों में अंतर है?
there is a
Yes.
there is a difference.
Right.
Now the word award, my lord, there is a reason why section 19 uses the word award, my lord.
हाँ,
Award is not defined
आपका
under
क्या कहना है कि गवाहियां करानी थी?
नहीं procedure which is enumerated under the act.
कौन सा प्रोसीजर उतना ही तो बता दो।
मैं हाँ बता दूं, arbitration and conciliation act.
हाँ, 18(2) का प्रोसीजर हो चुका।
18(2) साहब दो चीजों में है, एक
सर देखिए, आपने कहा था इट इज विदाउट jurisdiction because it was not followed.
जी,
मैं उतने तक ही रख रहा हूँ। I will not going to enlarge the scope of this petition.
जी.
18(2) was followed. Thereafter 18(3). If 18(3) was according to you was not in accordance
Yes,
with
madam.
law, refer under section 19, approach under section
My
19.
lords. Now, my lord, my lords asked the question, the procedure of arbitration.
हाँ.
What is the procedure for arbitration? Now, my lord, award is not defined under the 1996 Act, my lord. Award was defined in the 1940 Act, my lord. What is the meaning of the word award? My lord, to assist my lords on the aspect, my lord, may I be permitted to read the definition, what is of the award in the 1940 Act and the interpretation? It's a small paragraph if I just read it. This I'm referring to the...
अच्छा सर, मुझे ये बताइए,
जी.
if something is not defined in this act, then can we import the definition given in the previous act or some other act, or we have to look into the general definition of that word?
The arbitration, the answer to
Proper interpretation of statutes पे आ गए.
yes, the answer to that question would be the 1996 Act, when was formulated, my lord, it repealed the 1940 Act. Various provisions of the 40 Act was taken into consideration. The word award was never defined in the 1996 Act, my lord.
So you mean to say it was deliberately not done?
I should not say that it was not deliberate.
No, the moment you say that
Because
they were
the
considered, Sundar sir, the moment you say that they were considered, and if they were considered and it was not picked up, so that means it was a deliberate and conscious decision.
Because the word award is defined in the Madhyastham Adhikaran also.
सर मेरा सिंपल सी बात है ना सर, आप उस पे बहस कीजिए ना, इंटरप्रिटेशन ऑफ स्टैट्यूट.
मैं अवार्ड का एक बार...
अरे सुन तो लीजिए. If a word has been defined under an act, then we have to assign the same meaning whenever that word has occurred in the act. But if the word has not been defined, then whether we should look for the general meaning, definition meaning, or we can import the definition from some other acts, or the acts which have already been repealed. सर वो इंटरप्रिटेशन ऑफ स्टैट्यूट्स की किताब निकालिए ना सर.
जी, मैं
निकालिए ना सर प्लीज.
मैं लाया नहीं हूँ सर, because I've got, मैं आपको एड्रेस करना चाह रहा था दो चीजों पे. एक, the award and the procedure of the award, which is how the procedure.
सर जब आप ही ने कहा award has not been defined, तो हम फिर उस पे अटक गए. हमने कहा मना किया कि आप जो एड्रेस कर रहे हो गलत है. हम तो आपसे इतना क्वेश्चन पूछ रहे हैं कि if a word has not been defined, whether we can pick up the definition from a repealed act or some other act, or we have to give a general meaning of to that word.
Well, these are specific legislation, so
whatever it may be, every legislation is a specific.
But the 40 Act define.
सर आप पहले तो आपने किताब लाए नहीं हो, मैं क्या करूं?
मैं कल ले आता हूँ अगर आप
डिसाइड तो आज होना है,
तो मैं दो चीज पढ़ देता हूँ
सर. आप पहले तो लॉ बताइए, उसके बाद हम
तो then I'll refer section.
आप you are referring to the acts, the definition of some other acts which have already been repealed, and according to you, after considering everything, a new act was brought into existence.
Yes.
If that was considered, then that means this legislation has consciously and deliberately omitted to give definition to award, and then we cannot look into that act. We have to look for the general meaning of that act.
My lords.
अब आप फिर आ जाइए, ब्लैक्स डिक्शनरी ले आइए, फलानी सामान की डिक्शनरी ले आइए, जो भी लानी वो.
I've got the definition of an award, my lord, as per the Black's Law Dictionary. To grant by formal process or by judicial decree. The company awarded the contract to the low bidder. The jury awarded purity.
ठीक है ना, तो क्या आपको सुना नहीं था क्या? आपको सुना नहीं था?
नोटिस भी नहीं दिया आर्बिट्रेशन.
आपको सुना नहीं था? सुनिए सर, ऐसा नहीं है. Let us come to the previous order sheets. Everything was made known to you. Sir, let us come to the previous order sheets. Everything was made known to you.
Page number 8.
Sir, referring to just a minute, sir, please. The order sheets are at page.
The impugn order, my lord, sir.
अच्छा ये वो बात
आइए के साथ दी है उसमें
पेज नंबर
3 वाली ऑर्डर शीट में आया दोनों.
अब आप ये बताइए, पेज नंबर है 3/3/2023 का ऑर्डर है. समझौता करते हुए दिया 16 का 7 दिवस में परिषद को अवगत कराएं. प्रकरण अंतिम बहस एवं मध्यस्थम आदेश, ये तो नियत किया जी. You knew this fact that it will be argued finally in case if the mediation fails.
जी.
इसमें और क्या नोटिस की जरूरत?
इसमें arbitration की proceedings उसमें these because the
फाइल एंड देन वो सेक्शन 19 पे जाइए.
सर वो सेक्शन इसमें ये है कि the arbitration procedure has to be followed, मतलब that the notice has to be given, the evidence has to be taken into consideration, the place of arbitration has to be
Why you
set.
did not object to it?
मतलब the only objection which we took, my lord.
Why you did not object to it, sir? Because it was already written on 3/3/2023.
No, the only objection we took on 2/9/2020.
Yes.
That even the conciliation proceedings cannot go on because the arbitration appeal is pending before the Honorable High Court Division Bench. Because a Section 9 application.
आपने वो आर्ग्यू नहीं कर रहे हो.
नहीं, वो इशू भी नहीं था, सेक्शन
नहीं,
9 में वो आए थे, उसकी अपील पड़ी थी.
सेक्शन 9 में
उनकी
क्या
अपील
है
पे कैसे बीच में आएंगे?
सुंदर जी, वो तो वो आर्बिट्रेशन एक्ट का इंटरिम ऑर्डर का होता है.
Section 9 for
जस्ट टू सीज द प्रॉपर्टी दिस दैट.
उसको डिले
उसमें कहां से होगा यार?
sir, वो my lords are absolutely right.
My lords are absolutely right.
Yes.
That is a different thing. But the difficulty is that once it was already made known to you very specifically on 3/3/2023, that file the report within 7 days. अब उस दिन पता नहीं था कि arbitration successful होगा कि नहीं होगा. It was made specifically known to you that the next date will be either for final hearing or for consideration of the conciliation report. अब वो जब वो fail हो गया तो उन्होंने सुना, क्या कर सकते हैं?
Sir,
Go and file. No, sir.
my lord, I may just take my lords to the division bench order, my lord, because there are certain observation which I would bring it before my lords.
ये सेक्शन 9
नहीं, Section 9 का भी है plus interpretation also.
9 पे तो हम नहीं जाएंगे सर.
जी 9 पे नहीं जा रहा हूँ मैं 9 पे नहीं जा रहा हूँ.
नहीं, हम नहीं जाएंगे सर.
I'm only taking my lords to the interpretation because there were 3 issues which were considered.
Fine,
Section 9 application.
ठीक है.
One was the
अच्छा सर, ठीक है ना, तो क्या हो गया?
One was the applicability, my lords, of
The
the
file and approach the district court and district court में जाएगा ना?
Section 30 नहीं
34
34 में जाएगा.
34 में डिस्ट्रिक्ट कोर्ट जाएगा.
एक बार आप वो देख लें my lord, there's only one submission. My lords, just see the order passed by the division bench where the
कौन सा वाला judgment है सर?
वो इनका review का है सर. Arbitration appeal का, which my lords would find in the IA number 2.
सेक्शन 9 की थी.
नहीं सर, I am not denying.
ओ सर, अगर आपने दोबारा सेक्शन 9 को रेफर किया, राइट, और सेक्शन 9 स्पीक्स अबाउट द interim measures.
Aware of that.
They must have filed an application thereby restraining you from alienating
The release of
whatever it is.
No, I am not, my lord.
मुझे उससे मतलब नहीं है कि क्या
एडजुडिकेट हुआ है इसमें ऑर्डर.
नहीं, मैं
शायद जी, मुझे इससे मतलब नहीं कि क्या एडजुडिकेट हुआ. मुझे इससे मतलब है कि the scope of section 9 is an interim measure, that is all.
now final order is
I'm not disputing.
And Mr. Sundar, it is well established that in the finding given at the interim stage
Is not-
cannot have any
Yes, that's
binding
the-
on the final stage.
That's the settled law.
Forget about section 9.
I'm not referring to section 9. What I am trying to draw your lordship's attention to the aspect is the division bench has interpreted the applicability of the 1996 Act with relation to the 2006 Act.
ठीक है.
I'm just referring 2 paragraphs.
कौन सा जजमेंट?
You have to take consideration of IA number 2857, which was filed on 26/2/2020.
क्या है पेज नंबर?
मतलब page number में my lords may come to page number 20, my lord. I'll just refer to 2 pages, my lord.
And actually paragraph
19 onwards, my lord.
19.
May I read it, my lord?
अच्छा सर, जो सब्जेक्ट मैटर होगा उसी के कंसर्निंग तो फाइंडिंग्स होंगी ना,
हाँ, वो होंगी सर.
या उससे बाहर की भी
नहीं,
हो
उससे
सकती
होगी,
है?
but the division bench had gone a step ahead and
ये 1996 का जो एप्लीकेबिलिटी का एक्ट है, क्या क्वेश्चन है, ये कौन सा एक्ट है सर?
ये arbitration and conciliation.
आर्बिट्रेशन. चलिए, तो इसमें जो भी फाइंडिंग्स हैं दैट इज विद रिगार्ड टू 1996 एक्ट.
Yes, my lords.
Fine.
My lords. And the section 18(2) of the MSME Act talks about arbitration and conciliation proceeding which has to be done as per the 1996 Act.
ठीक है ना
जी.
सर?
So
there, my lord, the finding
may I-
was
may-
section
may I
9
read it?
won't be maintainable till conciliation is not failed.
may
That
I-
was the finding,
No,
my
no.
lord, and it has got
That is-
nothing,
that
no
is-
bearing on this
My
order.
lord, that is one part of the finding. What is the?
This is misleading.
No, why it is? I'm reading the order of the division. I may be wrong in an interpretation. I may be absolutely wrong in interpretation.
तो मैंने कुछ मना किया क्या?
The objection what has been raised that
तो
I'm
आप
misleading this court.
आप उन्होंने नहीं कहा कि मिसलीड किया.
He just said
मतलब
it.
शेखर जी के ऊपर आप मेरे पे क्यों नाराज हो रहे हो?
But
Huh?
if the allegation is put on me that I'm misleading the court, my lord, I may be.
He has not used the word. He has not used the word misleading.
That's what I heard. This is absolute.
बोला था
misleading.
क्या?
उसने बोला misleading.
So
बोला
I
था?
take my words back, if I've taken that.
चलो, unconditionally withdraw.
So what I'm just reading two paragraphs, my lord.
हाँ,
The applicability of the Act of 1996 is one issue.
हम्म,
However, the stage of applicability of the Act of 1996 is another issue.
हम्म,
The scheme under Section 18 of MSNME Act not only expressly provides for applicability of the Act of 1996, but also the stage of applicability, which is clearly reflected for the use of term then, which is incorporated in subsection 3 of Section 18 of MSNME Act 2006. There are two stages of applicability of the Act of 1996. As per Section 2 of the MSNME Act 2006, for the purpose of conducting conciliation, there is a limited applicability of Section 65 to 81 of the Act of 1996.
हम्म,
Thereafter, the application of Act of 1996 comes in the picture only when the conciliation, which is
सेक्शन
initiated,
9 नहीं आएगा, पिक्चर में नहीं आएगा,
subsection 2 of Section 18 is not successful and stands terminated.
कोई बात
Thus, the stage from which the Act of 1996 starts to apply is clearly mentioned in Section 18.3 of the MSNME.
नहीं.
Now, my lords, may come to para 21, at
Hmm.
page 21. Section 18.2 of the Act also provides that upon receipt of reference under subsection 1 of Section 18, the Council itself can conduct the conciliation or seek assistance of any institution for conducting the conciliation. The provision under Section 65 to 81 of the Act of 1996 will be applicable to such conciliation proceedings. It is germane to mention at this juncture that the provisions of Section 65 to Section 81, to the exclusion of the Act of 1996, deals with the procedure of conciliation proceedings, meaning thereby that till the stage of Section 18.2, the applicability of Act of 1996 is restricted only to Section 65 to Section 81, to the exclusion of all other sections. Then Section 18.3 of the Act of 1996 provides that once the conciliation so initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the Council can itself take up the dispute for arbitration or refer it to any institution or center providing
Whether
alternative.
the word arbitration has been defined under this Act, 2006
I'll
Act?
just check. No, my lords. Section 2 definition does not mention arbitration.
Then, sir, how that observation has been imported from this 1996 Act? How it
Because,
can be imported, sir?
because Section 18.3 mentions specifically the arbitration.
आर्बिट्रेशन वर्ड है ना सर, मैं तो सिंपल सी बात कह रहा हूँ ना, मैं तो वापस जा रहा हूँ इंटरप्रिटेशन ऑफ स्टैट्यूट्स पे. आपने अवार्ड की भी बात हुई थी, वही बात तो मेरी आर्बिट्रेशन वर्ड से भी लगेगी ना.
The applicability of the Act.
सुंदर साहब, इट इज एन इम्पोर्टेंट क्वेश्चन, आप इतना लाइटली क्यों ले रहे हो उसको? व्हाट इज द जनरल प्रिंसिपल्स ऑफ इंटरप्रिटेशन ऑफ स्टैट्यूट्स? ऐसा तो नहीं है ना कि किसी एक स्टैट्यूट में जो वर्ड यूज नहीं हुआ है वो कभी किसी और में हुआ ही नहीं होगा. और उसमें जब ये लॉ है कि इफ एनी वर्ड हैज नॉट बीन यूज्ड देन इट हैज टू बी गिवन अ जनरल मीनिंग. क्या इंटरप्रिटेशन ऑफ स्टैट्यूट्स में इज इट परमिसिबल टू इंपोर्ट अ डेफिनेशन ऑफ दैट वर्ड फ्रॉम एनी अदर एक्ट? That is the only question which I am putting for the last 10 minutes or 20 minutes.
No, that question I cannot answer without referring to the.
Then what can I do?
That question I cannot.
Because the general law which I know is that if a word has not been defined under the act, then the general meaning of that word has to be
taken into
account. General meaning means the meanings of the even dictionaries and all these things. Now, if we import the procedure prescribed under the Arbitration Act into this MSME Act, is it permissible? मैं इतना सही रिक्वेस्ट कर रहा हूँ. वो पासिंग कमेंट है जो आप एक लाइन पे जो पैराग्राफ 22 पे जा रहे हैं, इट इज अ पासिंग कमेंट, राइट? दैट वाज नॉट द सब्जेक्ट मैटर ऑफ द डिस्प्यूट इन दैट केस. और पासिंग कमेंट के ऊपर क्या लॉ है ये भी आप जानते हैं, राइट? Therefore, I have to decide it whether the procedure prescribed under the Arbitration Act will apply to the word arbitration mentioned in the MSME Act 2006 or not.
Then, my lord.
So therefore, I was requesting again and again that if a word has not been defined, then how that word is to be interpreted? By importing the definition from the other acts? उतना तो आप मेरे को बताओगे ना.
May I answer it in a slightly different manner? मैं लोग taking
कितने different manner?
थोड़ा सा.
थोड़ा सा देखो।
Section 18.3 very specifically, well, just here. Section 18.3 very specifically says that the provisions of the Arbitration and Conciliation Act will be followed.
जस्ट अ मिनट, ये कहाँ पे लिखा है सर? मैं वही मैं पूछ रहा हूँ, हो सकता है मैं स्किप कर गया हूँ। एक मिनट। Where the conciliation initiated and is not successful and the end stands terminated without any settlement, the council shall either itself take up the dispute for arbitration or refer to it any institution. ओके, ये तो आंसर है मेरे क्वेश्चन का, आंसर इसी में है। शेखर जी, व्हाट हैव यू टू से अबाउट दैट? मैं एक्चुअली ऊपर की 2 लाइन पे आके रुक गया था।
65 to 81 of the arbitration conciliation 1996 shall apply to such a dispute as if conciliation was initiated in part 3 of the act, my lord. Now, my lord, everything was done. Now, there is a time limit of 90 days where this entire proceedings have to be concluded, my lord. It concluded, it started in 2020, my lord, and it continued for more than 2 years, my lord. Now, everything was...
तो उससे क्या फर्क पड़ता है? आपको इतना हाई रेट ऑफ इंटरेस्ट मिलेगा?
नहीं, पहले तो हमारा देखिए, what has happened, the entire pleading was taken upon the record. My reference was there, their reply was there, the rejoinder was there, everything was there. What would have they done, my lord, after that?
Page 25 अच्छा, वो
page 25
arbitration and conciliation,
my lord, may come to page number 25, my lord, of the award, my lord. That page 25 of the petition, my lord. Internal page 9 of the award, my lord.
Arbitration and Conciliation Act नहीं है आपके पास?
If I may pass this.
अरे
This reads, my lord, काउंसिल ने प्रथम नोटिस दिनांक सो एंड सो से अनावेदक द्वारा प्रस्तुत दावा आवेदन पत्र आवेदक को भेजकर 15 दिवस में बिंदुवार उत्तर और सुलभ प्रस्ताव दोनों अलग अलग उत्तर और सुलभ प्रस्ताव प्रस्तुत करने निर्देशित किया था, किंतु आवेदक द्वारा सुलभ प्रस्ताव प्रस्तुत नहीं किया। सुनवाई क्रमांक 200 में आवेदक को सुलभ समझौते का अवसर प्रदान किया गया, किंतु प्रस्तुत जवाब दावा अनुसार आवेदक द्वारा आवेदक का दावा की गई राशि को पूर्णतः अस्वीकार किए जाने से उभय पक्षों के मध्य सूक्ष्म लघु और मध्यम उद्यम विकास अधिनियम की धारा 18(2) की सुलह की कार्रवाई पूर्ण होकर विफल रही। आवेदक द्वारा प्रस्तुत जवाब और सुनवाई में प्रस्तुत किया गया आवेदन पर दिनांक 9 आर्बिट्रेशन देन द आर्बिट्रेशन मैटर इज टेकन खारिज कर दिया गया। सुनवाई दिनांक 2/9 को आवेदन को प्रस्तुतिकरण किया गया। काउंसिल में जो प्रकरण है वह बिल पेमेंट के लिए तथा उच्च न्यायालय में प्रकरण लंबित है व आवेदक की जब्त की गई मशीनों के प्रदाय के संबंधित है।
सर सेक्शन 24 पे आइए, 1996 एक्ट।
Hearings and written performance. Unless otherwise agreed by the parties, the arbitral tribunal shall decide whether to hold oral hearings for the presentation of evidence or for oral argument, or whether the proceedings shall be conducted on the basis of documents and other materials. Provided that the arbitral tribunal shall hold oral hearings at an appropriate stage of the proceedings on a request by a party, unless the parties have agreed that no oral hearing shall be held. Provided further that the arbitral tribunal shall, as far as possible, hold oral hearings for the presentation of evidence or for oral argument.
अब आप मुझे बताइए, unless otherwise agreed by the parties, the arbitral tribunal shall decide whether to hold oral hearings for the presentation of evidence, or end word नहीं है, or for oral argument, or whether the proceeding shall be conducted on the basis of documents and other materials.
Yes, ma'am.
जब उन्होंने ये होल्ड कर दिया कि फाइनल आर्गुमेंट्स के लिए हम फिक्स कर रहे हैं, did you move any application seeking permission to lead any evidence?
No, ma'am.
That was the last on the last occasion before this came to this honorable court, my lord. This was a pertinent question asked to them whether they raised any objection. There, they didn't do it, my lord. And there is a procedure.
34 पे जाना पड़ेगा.
The councils there did not object to section the objection, or they did not file any application seeking evidence.
Then you have a remedy against your counsel, sir. Why should I repeat again and again?
No. I'm not.
Why should I repeat again and again? If your counsel was not vigilant enough, and if you feel that he is guilty of misconduct, approach the bar counsel.
I never said that.
If you, the
only thing was the question.
I'm not saying that what you should do.
The question was asking whether an application or any.
What I am suggesting, once you have given an authority in the form of wakalatnama, then you cannot put a blame on the counsel. Right?
Well, then there is an error in the procedure, man. I may admit that
Not
there is
for
an
that lot true.
3067/2023, Shri Sundar, counsel for petitioner, Shri Shashank Shekhar, counsel for the respondent. This petition under Article 226 of Constitution of India has been filed against the order dated 6/9/2023 passed by Madhya Pradesh Micro and Small Enterprises Facilitation Council Bhopal in MSEFC /1152/2020. It is submitted by counsel for petitioner that since the Facilitation Council has acted contrary to the established procedure of law, therefore, the petitioner may not therefore, the petitioner can assail the same by filing the present petition and may not be relegated and may not be asked him to avail the statutory remedy of approaching the district court under section 34 of Arbitration and Conciliation Act 1996. By referring to the award dated 6/9/2023, impugn awarded, it is submitted by counsel for the petitioner that after the conciliation had failed on 3/3/2023, the Facilitation Council should have fixed the case for recording of evidence by adopting the procedure as laid down in Arbitration and Conciliation Act 1996. However, directly fixed the case for recording for delivery of for final arguments, and thus the procedure which was adopted by the Facilitation Council was unknown to the settled principle of law. Therefore, the statutory remedy of approaching the district court under section 34 of Arbitration and Conciliation Act 1996 is not efficacious, and it is well established principle of law that if an order has been if the order passed by the authority is without jurisdiction, then it can be challenged by filing a writ petition under Article 226 of Constitution of India. Par contra, the petition is vehemently opposed by counsel for the respondent. It is submitted that the petitioner has an efficacious remedy of approaching the district court under section 34 of Act 1996, and in order to avoid the payment of the statutory amount as provided under section 19 of the Act 2006, the petitioner has approached this court directly. Refuting the aforementioned submission made by counsel for the respondent, it is submitted by counsel for the petitioner that he has not approached this court with the intention to avoid the deposit of statutory amount, but since the procedure adopted by the Facilitation Council was unknown to law, therefore this petition is maintainable. It is further submitted that he would confine his arguments only to the procedure adopted by the Facilitation Council and would not touch the merits of the case. Consider the submissions made by counsel for the parties. Section 18 of MSME Act 2006 reads as under. From the proceedings of the Facilitation Council, it is clear that the conciliation had failed on 3/3/2023. And the counsel for the petitioner has filed the complete order sheets of the Facilitation Council along with IA number 5200/2024. From order dated 3/3/2023, it is clear that the Facilitation Council had fixed the case for conciliation and also fixed the case for final arguments on the next date. On 3/3/2023, the conciliation failed, and accordingly, the case was taken up on 21/7/2023. That is 21/7/23. And on the said date, a statement was made by the parties that conciliation has failed. Accordingly, the final arguments were heard, and award dated 21/7/2023 was passed. It is submitted by counsel for petitioner that since the word arbitration has the same meaning which has been given in the Arbitration and Conciliation Act 1996, therefore the Facilitation Council was under obligation to record the evidence of the parties, and once that aspect, that procedure has been skipped by the Facilitation Council, therefore the award passed by the Facilitation Council is bad in law and without jurisdiction. Consider the submissions made by counsel for the petitioner. Section 21 of Act 1996 reads as under. No, sorry, 24 of Act reads as under. If the order dated 3/3/2023 is passed by Facilitation Council is considered in the light of the provisions of Section 24 of Act 1996, then it is clear that the Facilitation Council had specifically made it clear that the proceedings shall be conducted on the basis of documents and other materials by fixing it for final arguments. I consider then it is clear that by fixing the case for final arguments, the council had already decided that proceedings shall be conducted on the basis of documents and other materials. If the petitioner was of the view that if the petitioner wanted to lead any evidence, then he could have filed an application seeking permission to lead evidence or to cross-examine the respondents' witnesses. However, such an application was not filed. Or once the petitioner has accepted the procedure decided by the Facilitation Council to hear the matter finally, thereby making it clear that the proceeding shall be conducted on the basis of documents and other materials, then it cannot be said that the Facilitation Council had committed any material illegality, thereby vitiating the entire proceedings. Under these circumstances, this court is of considered opinion that the Facilitation Council did not commit such a material illegality warranting bypass of the statutory remedy as under Section 34 of 1996 Act. Accordingly, the petition is dismissed with liberty to the petitioner that if so advised, then he can approach the appropriate forum under Section 34 of 1996 after complying the provisions of Section 19 of 2006. इसमें कोई कंडोनेशन ऑफ उसकी कोई एप्लीकेशन का प्रोविजन है क्या? तो डिफर
2006 एक्ट इज साइलेंट
है ना, तो फिर तो कोई वो है भी नहीं है. You have to do for it. Sure.
Great feelings.